Hey everyone, welcome back to another episode of Law Schoolers, and we are continuing our discussion in criminal procedure, and we are continuing our discussion on reoccurring searches. In this episode, we are going to be focusing on reoccurring searches within houses and workplaces. In houses particularly, we will be focusing on the outer boundaries of homes, also known as the curtilage. And then in workplaces, we will be talking about those areas where a workplace is treated like a home because most people spend a lot of time in the workplace. Let's go ahead and start with the outer boundaries of homes. Well, searches of homes are afforded the most constitutional protections within the Fourth Amendment. The tricky part is knowing exactly what is included in the definition of home, or the curtilage, which is the immediately surrounding area of the home, and then also what is open fields, which is anything beyond the curtilage. So how do you define home, curtilage, and open fields? Well, our first case that we have to illustrate this is State versus Fisher, and then we have State versus Dixon. State versus Fisher is going to define curtilage, and State versus Dixon is the open fields doctrine. So State versus Fisher, what is our rule? Well, you can't search a home or curtilage without a warrant that is based on probable cause. If you don't have a warrant, you can't search it. For curtilage, the warrant may be accepted by a lack of reasonable expectation of privacy or the plain view doctrine, which means inside the home, you need the warrant hands down. For curtilage, you need the warrant hands down, except if there is a lack of reasonable expectation of privacy or if it is within the plain view doctrine. The plain view doctrine, if you remember from a previous episode, we talked about it. It's a good example of it was the case where officers went to a storage unit, they went into the neighboring unit where they were allowed to be, and they saw a little hole, and in that little hole they were able to see into the neighboring unit and discovered evidence of a crime that was ongoing in that unit and used that as evidence, and that evidence was not excluded because of the plain view doctrine. That is, the officers were lawfully allowed to be there, and because they were lawfully allowed to be there and could plainly view this evidence through that lawful place, that evidence is able to come in at trial. That is the plain view doctrine. And the reason why the plain view doctrine exists here is because you have a lack of reasonable expectation of privacy. If you're publicly displaying that, or if people from a lawful area could see those activities, you don't have an expectation of privacy. You can't, because you're publicly displaying those things for other people to see. Much like me doing this podcast. It's a little uncomfortable, but I'm publicly displaying it. So I don't really have a reasonable expectation of privacy as far as what I share on this podcast goes. That kind of principle. So for curtilage, you need a warrant, but if you don't have a warrant, a lack of a reasonable expectation of privacy on the part of the homeowner or the plain view doctrine can be used to destroy that need for a warrant. So what is curtilage? Well, State versus Fisher defines curtilage as the area that harbors the intimate activity associated with the sanctity of the home and the privacies of life. So how do we determine whether or not something is within the curtilage of the home? Because the curtilage is the outer boundaries of the home. Well, there's something called the Dunn factors that Fisher quotes. And we are going to be looking at the proximity to the home, whether the area is enclosed either by a fence or some other kind of barrier, bushes, trees, whatever it might be, how the area is being used, if it's being used for intimate activities of life, or if it is being used where people can just go and use that area publicly, where it's still your property, but you're not really going to be mad at them, that kind of thing. And whether the owner took steps to protect the area from public observation. If those steps are readily apparent, that is going to lead the officer to believe that it is within the curtilage. So, what happened in State versus Fisher? Well, the officers, they had observed some trash in the backyard of Fisher's place and the officers went onto the property, went and knocked on the door. There was no answer. As they exited the property, they decided, we'll take the long way around. They went to the backyard and discovered in that trash can ingredients for creating an illegal drug. These ingredients were then used to obtain a warrant. The warrant was executed and used to discover more evidence that led to Fisher's conviction. He's saying, well, this wasn't cool. You went into our backyard, and that's where you discovered this evidence. And the officers are saying this is not within the curtilage because the garbage was on the driveway. It was on the backside of the house, but it was still on the driveway. So looking at those factors, proximity to the home, it was in between the main building and a barn, so it's still pretty close to the home. Whether it is enclosed, well, you kind of had to go out of your way to get there. They had a fence, and the only accessible way was through the driveway. How the area is used, well, the area is used as a backyard, and then whether the owner took steps to protect the area from public observation. Well, this is by putting the garbage in the backyard for disposal rather than in the front yard where most people put things for disposal. So steps were taken to prevent public observation, and the evidence in Fisher should have been excluded at trial. Okay, so let's talk about State versus Dixon, the open fields doctrine. What happened here? Well, the officers had obtained a tip that drugs were being grown in a pretty rural area. When the officers searched the area, they passed several signs that had said, no hunting, but they ended up passing those signs, and they discovered drugs on the defendant's property. So the open fields doctrine, an open field is an area beyond the scope of the home and curtilage. In other words, once you go beyond curtilage, everything else is open field. It is everything else. The Fourth Amendment provides no protections to open fields, and so using the acts here in this case, this was an open field, so there are no Fourth Amendment protections, and the search is valid. State law could restrict this by giving a definition of how to enter or what you do if there's signs, or this would have been a much closer case if the sign said no trespassing instead. If there was a gate before the officers had to get onto the boundary, whatever else it might be. In suburban areas, though, courts are pretty divided on saying what's curtilage and what's open fields. Could look at a couple of cases. For example, People versus Thompson. It's a California case. It said that all the property within a suburban area is curtilage. And then Hart versus Myers, which says that not all of the property is curtilage. Okay, so let's look at one more example of curtilage. We have Espinoza versus State. Here, the officers had a search warrant for apartment B, but the officers found drugs that were closer to apartment A along apartment A's side of the driveway. So the question is whether or not the warrant is going to cover the seizure because the drugs were found on the curtilage of apartment A instead of on property apartment B, as the warrant had ended up calling for. Well, what happened here is that this was within the curtilage of apartment A, but and that's what this district court said. But the Supreme Court, the state Supreme Court here, said that it was open fields. And so what is our takeaway here? Well, curtilage zones can vary depending on if you're just doing a little barrier around your side, or if you're extending it to the porch, or if you're extending it to the end of the driveway. Curtilage zones can vary, and that is something that happens on a state-by-state basis. So that's Espinoza versus State, and that is our discussion on outer boundaries of homes and then curtilage. So let's move now to our discussion on workplaces. We have People versus Galvedon. This is a pretty fun case. What happened here is that Galvedon worked at a gas station. Him and I believe it was his mother-in-law. It might have been his mother, but I think it was mother-in-law were the only two people who worked at the gas station. The mother-in-law was the owner, and Galvadon was the only other employee. And they both used the back area, the back room, for whatever, kind of as an office. I think they were running a gas station, really, and the back office here is where evidence of crime was being contained by Galvadon. Well, the officers ended up... Well, what happened is that people were outside of the store, and as officers were passing by, those people got into a fight. Poor timing on their part. The officers ended up stopping the fight, bringing them inside because pepper spray was involved, and asked if they could use the bathroom, which was in the back room. It was the only place where there was a bathroom. And Galvadon said no. You can't go back there. Despite the efforts, the victim of the fight ended up going back there anyways to use the bathroom. Officer followed. And in the process of this, the officer discovered the evidence of drugs that Galvadon was keeping in the back room. So, this evidence was then used to convict Galvadon at trial, despite his efforts to have the evidence excluded, saying that this was an unreasonable search and seizure of that evidence. So, what is our rule here to determine whether or not this needs to be excluded? Well, we need to determine whether or not the subject here, Galvadon, had an expectation of privacy against government intrusion, and when there is no surveillance camera, there was a surveillance camera in this case, I forgot to mention that, but when there is no surveillance camera, the courts are going to consider whether or not the work area is exclusively used by the employee, and whether the employee has the power to exclude access to this work area. Well, when there is surveillance cameras, as was the case here, the courts are going to also consider whether or not that surveillance is available to the public, and there is no and the expectation of privacy may be reduced regarding the store owner, but not the government. So in this situation, Galvadon had a minimum expectation of privacy to his mother-in-law, the store owner, but his expectation of privacy was still high against the government because this area was exclusively used by him, and he believed he had the authority to exclude others from that area. And so the surveillance camera, yes, there was surveillance camera, but that was readily accessible only to the store owner, and that's why the expectation of privacy is diminished as to the store owner, but not to the government. I do want to mention, though, that the expectation of privacy is not presumed. It must be proved by the defendant. So, in this situation, Galvadon's evidence was wrongfully admitted and should have been excluded because he had an expectation of privacy, and there was no warrant to go back there or probable cause to go back there. The officers were in their wrong to use that evidence against him at trial. I do want to mention the dissent. The dissent argues that the reasonable expectation of privacy does not exist in this case because the back room was readily subject to searches, and this is because it's a highly regulated industry. And I misspoke by saying that it was a gas station. This was a liquor store. So it's a highly regulated industry, and for that reason it's subject to administrative searches anyways, without a warrant, or actually, going back to our warrant discussion, it does require a warrant, but probable cause is a lot easier to define, or rather, a much easier aspect to meet. And you could argue that there was potentially an exigent circumstance in this situation too. Okay, so that's our Galvadon message. I do want to note a couple other things. The store owner in this situation could have provided the officers with the camera evidence, and there would have been no issues. The owner could voluntarily hand over the evidence if asked, but if the owner is acting as an agent, and to determine whether or not the owner is acting as an agent, you need to see whether or not the police asked for it, and the individual acts with the intent to assist the police. If they do that, then they're considered an agent. If they are acting as an agent for the police, well, then that evidence can still be barred. But you're going to look at whether or not this was voluntary or not. One final thing to discuss is that this case is going to argue the expectation of privacy against the government is not reduced, even though the expectation of privacy against an employer would be. This is not going to be the case for government jobs. The government does not need a warrant to conduct a non-investigative work-related search, and they do not need a warrant to conduct an investigation on work-related misconduct. That's, again, when it's the government jobs that are at issue here. So, what did we learn from this episode? We talked about the definition of a home, the curtilage, and open fields. Those definitions came from State versus Fisher, State versus Dixon, and Espinoza versus State. And then we talked about workplaces and how a workplace can be considered like a home in the sense of you have a reasonable expectation of privacy within the workplace if you're using that area exclusively, if you've got your little cubicle that you're working at and you feel like you have the right to exclude others access to that work area. If there's surveillance cameras, that adds a little other wrinkle. You're just going to consider whether or not that surveillance is readily available to the public. And then we talked a little bit about employers being an agent to the government, whether or not they're being an agent when they are asked to hand over material related to evidence. Okay, so that's everything, and I will catch you later. In our next episode, we are going to be continuing our discussion, but on schools and prisons. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.